do stay on mute. Good morning, good evening, everybody. We're really excited to have Chandhiok and Mahajan today with USIBC to talk about competition policy. We have a group of experts, and we're really excited about talking about this issue today. Competition globally has been an issue of increasingly importance. And in India, there's lots of talk about separated digital competition policy as well. India, of course, has a very strong history of competition policy. It also has a strong standing relationship with the United States. And so we're really pleased to have experts from both sides today for this discussion. I always like to say that competition policy is one of the most important policies out there. If you get competition policy right, a lot of the other aspects of regulation fall into place. And likewise, if you get it wrong, it constricts the economy writ large and impacts other sector regulators. So therefore, I think that the timing is super critical that we talk about competition today about India, but also within the global framework. And to have, lawyers of the caliber that we have today, of Avinash Amarnath, he is a partner at Chandhiok, and he's got decades of experience, and he's dedicated to competition, and he's worked with major companies, and has experience with the Company Law Appellate Tribunal, which is a really critical aspect of this as well. So we have the competition policy, of course, then we move up to the judicial side. And also we have Diksha Manchanda, who is also a partner at Chandhiok and Mahajan. And she is actually very involved in competition matters in the Asia Pacific. And so having that global experience, I think, is going to be really important as we talk about what's going on in India, given what's happening overall in competition policy globally. And of course, from the American side, we're really pleased to have Ashish Agrawal join the conversation later. Ashish is a former US regulator. He works for the Chamber of Commerce GRC program, Global Regulatory Cooperation Program. And therefore, we can talk about India, US-India relations, and how competition policy is changing globally. So with that, I'm going to ask our members to go off video so that we can see the slides and showcase our speakers. Please do stay on mute. And please do note that this meeting is being recorded. If you do have questions, feel free to raise your hand. We can invite you to come on video and ask your question directly, or alternatively, you can type your question into chat and we can capture it on the backside. So with that, Avinash, I'm going to ask you to pull up your slides, and I'm going to go on mute and off camera and put it on yeah, exactly. And over to you, sir.
Thank you, Jay. I hope I'm audible to everyone. Pleasure to be speaking on a very, very important topic, I think, to a chamber and its members who are critical to the development of this law as well. So today, I think what the purpose of this presentation is primarily to present what we see happening in 2023 in India. And as Jay was mentioning, this is a very, very interesting time to be a competition lawyer. There's so much happening. It's almost difficult for us also to just keep track. So much happening. So just, I think what we're going to, and we have a limited time frame here. So what we're trying to give you here is mostly the highlights, but there's a lot of change. So I think and just to quickly start from where all of these changes happened, is that the competition law in India, especially the antitrust provisions, came into force in 2009. So after exactly a decade of enforcement of the competition law, it was felt by the government that we need to review the law to see if there are any gaps in enforcement. Do we need any changes? But more importantly, what had happened in the economy, in the global economy in these 10 years, is that the way business was done has undergone a sea of change. Just especially, I mean, there are so many changes, but I'm just going to highlight two things that really changed. One was the adoption of asset-light models, your Ubers and all your platforms, where essentially it was felt that you didn't need to own the asset. As long as you had a platform to connect a buyer and seller, you could do business. And second, of course, is what traditionally has existed, two-sided markets, but then when they came into the digital space, they took on a dimension that many people had not imagined. So I think these changes prompted a review of the law. And so hence, 2019 for India is the starting point when a competition law review committee was formed to look at the existing law and to see if there are changes required. July 2019, the CLRC submitted its report. And basis that report, February 2020, the first draft of an amendment to the Competition Act in India was introduced and public comments were invited. Since then, we have been in a bit of a limbo, if I may say so. The amendments have still not been passed into law, but that's because there's still a lot of churn and a lot of comments coming in. So the next real big milestone was in December 22, when a parliamentary standing committee of the Indian Parliament released two very important reports. And these reports will form a major chunk of the developments that have happened and what we'll highlight in the slide deck. One was on the amendment to the bill. They released their suggestions. And secondly, a separate report, which is popularly called the Big Tech Report, was a report on the digital markets and whether we needed separate regulations or anything extra to regulate digital markets. February 2023, reportedly, a revised bill has been released, and we expect that bill to be introduced in the next session, which takes into account the suggestions in the December reports. So that's where we're at broadly on a timeline. So we broadly divided this into three buckets. We are looking at enforcement, which is your anti-competitive agreements and abusive dominance provisions. Then we're looking at procedural aspects, and we're looking at merger control and what are the major hits and misses in the amendments according to us. I'm conscious of the time, so I don't think we'll be able to cover all of them. But I think the big one that I'm going to take up is settlement and commitments, because many of you would be aware, prior to 2019, the Indian competition law, one of the major lacuna that everybody agreed was that there was no provision for settlements and commitments. This meant that very often, even if the complainant and the opposite party had settled the matter amongst themselves, the competition authority would continue with its investigation because they said we don't have powers to accept a settlement or commitments from the parties. So a provision for settlement and commitments has been introduced into the bill. Of course, there are still glitches in the way the system works. I think, and I was there on the CLRC when the settlement and commitments provision was drafted. In fact, I might say I was the person who drafted the initial first draft provision. Of course, it's undergone a lot of changes after that. But I think the idea, and because I remember the discussions that happened in the CLRC back then, but the idea of introducing settlements and commitments in the way it is in the bill was to actually just have a broad enabling provision in the Act with the nitty-gritties left to be sorted out in regulations, which is why you would see that there are a lot of details missing. But of course, whether these would be introduced into regulations and whether perhaps these should have actually been in the law itself is a question. Because one of the first thing, and you would see on the right-hand side, the first miss, according to us, is that there's no clarity on admission, whether there is a requirement of an admission for settlement and commitments. Because very often this is a big, this becomes a big problem for companies who want to come forward for settlement or commitments, whether they are required to admit guilt or not. There's no clarity. Perhaps in the regulations, we would see something on this, but as of now, the Act doesn't have it. The parliamentary report, the December report of the standing committee had recommended that that regulators should not insist on an admission because that may discourage parties from offering settlements and commitments. But the law is silent on it, so we'll have to see what happens. The second aspect about settlement and commitments is, of course, in India, there is a provision for follow-on damages claims once the regulator's order comes out. So interestingly, the amendment as it stands now seeks to make a distinction between commitments and settlement. Because I believe, and this is my reading, I may be wrong, but the lawmakers perhaps see a settlement more as an admission of guilt and then just a negotiation on the penalty. So you offer a settlement and then you settle at a penalty amount. And therefore, the amendment bill allows compensation and private damages claims basis settlements. Whereas in commitments, perhaps the lawmakers see this as a without prejudice offer of changing your behavior. And therefore, for commitments as of now, no compensation claims are allowed. Apart from that, I think the other big miss, according to us, is that the settlements and commitments provisions are only applicable to vertical agreement cases and abuse of dominance cases. Cartels have been left out of it. The rationale supposedly is that cartels are very, very serious offenses, and therefore we shouldn't allow settlements and commitments. However, the standing committee report again of the parliament had recommended that there was no reason for cartels to not be included, and whether it's a serious offense or not is something that can be decided on a case-to-case basis. So this is broadly on settlements and commitments. Apart from this, I think the other one that I would just like to highlight in this list particularly, because this I think plays a major role in the whole digital market setting, is that the Standing Committee of Parliament had recommended that for abuse of dominance cases, there should be an effects analysis. And this should be written into the law that an abuse of dominance can be a contravention of the Act only when there is an actual adverse effect on competition. This is consciously not included in the amendment and is something that, at least with our interactions with the CCI, we see that they are still sticking to the I would say this older European approach where they see that when you are a dominant player, any conduct that is considered abusive should be per se violative of the Act, because they see that the requirement of dominance itself is sufficient to, or rather, to put it another way, if you are dominant, then any conduct that you carry is likely to have an adverse effect on competition. So that is a bit unfortunate, although despite a parliamentary committee recommendation that not making it into the law. Of course, on case-by-case basis, whether courts can perhaps read that into the provisions, we'll have to see. But I think this was a good opportunity to put in something like that, and that's been missed. Moving on now to merger control. I think with merger control, the biggest introduction is what is called the deal value thresholds. So far in India, for a merger to be notifiable, you only looked at the assets and turnover of the parties. So this obviously, I think, especially in the digital sector, led to some major deals getting missed out. And the biggest example being, the Meta, the Facebook, WhatsApp acquisition. So I think that triggered in the regulator and the lawmakers the thought that apart from assets and turnover, we need some other metric to make mergers notifiable. And they have introduced what is the deal value threshold, or the value of the transaction. Now they haven't defined what is the value. They just call it the value of the transaction. They haven't defined what it is, whether it's equivalent to the consideration being paid for the acquisition, or how you calculate that, whether it's the valuation of the target, we still don't know. But that threshold has been introduced, which means that more mergers may get caught under that threshold. However, they have qualified it by saying that the target of the acquisition should have substantial business operations in India. But again, what is substantial business operations? We don't know because it hasn't been defined. But at least there is some, I would say, some amount of qualification on the deal value threshold with the local nexus requirement. I think on the positives, two things to highlight with respect to merger control is that earlier, especially with public offers, where you have the securities regulator, you're making an open market purchase on the stock market. there was a big conflict because the securities rules in India require that you have to close an offer within a certain period of time. Whereas under the competition regulator, you have a standstill obligation if you've notified a transaction to the CCI. So the two requirements were often clashing, and there was, in fact, case law which went all the way to the Supreme Court. But unfortunately, there wasn't a lot of clarity. That, thankfully, the law seeks to clarify by carving out an exception for open market purchases. Of course, there are some requirements that even though you complete the transaction and you purchase the shares should be kept in an escrow account and you should not exercise the voting rights you acquire. But you can complete the transaction as per securities rules. Similarly, another requirement which was already in place through a government notification is now sought to be formalized into law. People who are associated with competition law in India in their early days would know this. We had a very strange rule that you had to notify within 30 days of entering into a binding document or an agreement. That used to cause a major problem, I remember, especially in global transactions, because in other jurisdictions, this requirement is not there. Very often, India would be the first jurisdiction where you had to notify. And honestly, it didn't make sense because when you had a standstill obligation, when you notify, it doesn't really matter as long as you've not closed the transaction. So that was removed by way of a government notification 5 to 6 years back. That is now sought to be introduced formally into the law, giving more certainty and clarity. Then I'll move to procedural and other aspects. So in this, one of a few key highlights is that there are now a clear set of procedures as to how the Director General can carry on investigation. In an earlier iteration of the law, a disturbing aspect was that the DG could actually depose even lawyers, external counsel. But that thankfully has now been clarified by the latest amendment because they say that only in-house counsel can be deposed, not external counsel. Similarly, a good development is that there is a limitation period for filing a complaint. Earlier, there wasn't. So anything right from 2009, when the law came into force, one could complain of that conduct even today in 2023. But now there is, the law introduces a 3-year limitation period for filing a complaint. The other, a little bit of a contentious issue, but I think a welcome development, is that chairperson and members of the commission, once they retire, cannot take up any roles related to competition law or in terms of practice for a period of 2 years. So it's a cooling off period for members of the commission before they can take up other types of employment or roles related to competition law. On the misses side, I think one major aspect to highlight, which would be particularly problematic for global companies and corporations, is that earlier we did have the penalty could only be imposed on the relevant turnover, which was only the turnover generated from the product under investigation and within India. That the government is now seeking to change the definition of turnover to make it global turnover. However, I will qualify this. There are penalty guidelines expected. So hopefully within those guidelines, relevant turnover would be accounted for, because I am aware that in Europe as well, global turnover, the 10% cap is applicable on global turnover, but there are guidelines which then qualify how you calculate that penalty. So in India also, the law is providing for guidelines, and hopefully in those guidelines, relevant turnover will be accounted for. Second, according to us, a problematic piece is that now any appeals from the Commission's decision would be subject to a deposit of 25% of the penalty amount. First of all, 25% is quite a steep amount. And secondly, with my experience with the appellate tribunal, very often it depends on the facts and circumstances of the case. And personally, if you ask me, this should have just been left to the discretion of the appellate tribunal, because on a case-by-case basis, they could have decided whether a deposit is required and how much amount should be deposited. So having a strict requirement of 25% may be quite excessive in some cases. And the last problematic issue that has been debated for a very long time is that despite having court rulings which say that the CCI should have a judicial member, that requirement has not made its way into the law in any of its iterations. In fact, the standing committee considered the issue, but ultimately they said that because the issue is pending with the Supreme Court, Depending on what the Supreme Court says, they could take a call. But in my view, I think it is a no-brainer. You should have at least one judicial member on the commission, and this was a good opportunity to put this into the law, but they have left it to the courts. So now I think we'd have to wait for a longer time to see what happens on this issue. So these are as far as the amendments, particularly the amendments to the law is concerned. As far as the big tech report is concerned, I'll hand it over to my colleague Diksha.
Thank you, Avinash. But before we hand it over to Diksha, we have a couple of questions.
Yeah,
I think it would be fair to say that India's competition law hews more closely to a European model. We know that's probably true of a lot of regulation in India. The question from Kira is, do the amendments as proposed, do they continue that adherence to sort of the European standards, or are there aspects that might shift them to, American standards, which have slightly different directions?
I would, to answer that, Jay, I would say, in fact, actually, we seem to be moving the other way. We are probably a Europe plus jurisdiction. So we adopt Europe, and then we add stricter regulation to what is in Europe. So certainly we're not moving towards the US model. We're probably moving towards a Europe plus model.
Wonderful. Okay. Thank you for that. I guess the history of King's College as a degree for the competition lawyers shall continue. Great. Thank you.
I'm one of those. So.
Wonderful, wonderful. So Avinash, thank you very much for those remarks. We'll ask Diksha to come in and talk about the big tech report, and then we'll move over to Avinash after that. Over to you, ma'am.
Thank you so much, Jay. And thanks everyone, especially to our colleagues from the US. I know it's fairly early in the morning for you. So when Avinash and I thought about this, we thought that we would start with something that has hits and misses. But now the section that I'm looking at is unfortunately not so many hits, relatively less palatable to businesses. Not just big tech, but as I discuss it, you would realize every stakeholder in the technology industry is likely to get impacted by these changes. And these changes come from a Christmas present, so to say, from the Parliamentary Standing Committee. You would recall Avinash mentioned that towards the end of 2022, we got 2 reports from the Parliamentary Standing Committee of Finance. One was on the competition bill, and the second is the big tech report. The big tech report represents a massive shift in the way we have been looking at and understanding competition law and policy in India. It takes us into the arena of controlling each and every business decision of a company without really having a proof of anti-competitive conduct. This is very similar to what we are seeing across the globe. Europe has already implemented something called the Digital Markets Act, which is their version of ex-ante regulation, where they have come out with very prescriptive regulations of what companies can and cannot do if they are given a certain designation within the law. And we are moving dangerously close to that. In fact, I would say, again, typical of India, we are adopting something of a DMA plus model. This is also similar to what we are hearing in the US, with numerous attempts being made to change the way competition law has been perceived in the US. Now, what does the big tech report do? The big tech report says that there are certain entities which would be designated as systematically important digital intermediaries, or CIDs. The classification of CIDs would be on the basis of the revenue of the company, users, as well as certain other factors which would be decided collaboratively by the CCI and other stakeholders. So not much clarity on that aspect. But once you're designated as a city, you will be there will be certain rules and regulations which you will be required to follow. You can see some of them, actually all of them, to the extent the report has recommended on the slide. They will pertain to various different aspects of how a company works and runs. Some of the interesting things that come out are issues relating to data usage. There'll be a complete prohibition on cross usage or combining of personal data. Going to be a big problem where companies offer features which work between combining data across two different products. So for instance, and sorry, was there a question from anyone? Okay, great. So for instance, integration that is provided across two different platforms like Facebook and Instagram. There might be situations where that integration, which actually improves the customer experience, may have to be broken down because of the way these regulations might be implemented. There are concerns, the regulations around self-preferencing, which deal with giving better placement or better offers to the products of one company over those of the other. There are also a set of regulations which deal with whether a company can make their own product conditioned on use of another product. And those fall within the bracket of bundling in time, anti-steering, as well as third-party applications. All of them are essentially about a company combining two of its products together. Often quoted example in this space is that of a Play Store and the billing system that a Play Store uses. What we see in the report is the requirement for that part not to be intrinsic to one platform. So if we can demonstrate that the billing system is actually intrinsic to the Play Store, then some of these regulations may not apply, but it's out for debate whether all the others would still apply. There's also a move to cover advertising policies. And this is an interesting area because we've been hearing noises that it may be covered in the Digital India Act by the MeitY. So again, it remains to be seen how the clash of both of those is going to work out. But if that goes through, we're probably looking at something very similar to what happened in Australia, where the entire relationship between a publisher and the intermediary is regulated by law. As I said, all of this is not going to be good news for big tech companies, but beyond big tech companies, it will end up impacting all the stakeholders who are involved in the business environments and platforms created by the big tech companies. So from app developers to publishers to end users to sellers of goods, everybody stands to get impacted by how these regulations are going to play out. And I would venture to say that maybe that impact will not always be positive. Avinash, if you could move on to the next slide. So in this arena of what we call as ex-ante regulation of big tech, of course, the big tech report has come like a big bang. It has opened the channel of conversation around this. What we see with the report, though, is, I would say, a fairly half-hearted effort and attempt to justify the need for ex-ante regulation in India. Ex-ante is a big step. It's taking us back to the era where we said big is bad. And there has been in the report no economic assessment whatsoever, which would justify why ex-ante needs to be introduced and why it needs to be introduced in India, especially when you have the Competition Commission of India dealing with these issues on a day-to-day basis, coming out with orders, passing directions. All of that has been happening. So why do we need a more intrusive regulation? That is something that the report does not answer. Another issue that remains hanging in the air is what will be the enforcement mechanism for an ex-ante regime? If somebody who's designated as a city decides not to implement one of their do's and don'ts, what is the impact? How will the enforcement flow? And finally, I think the designation as city, that is going to be a very, very crucial aspect for all of us to follow and see how it develops. The definition indicates that cities are going to be product-based classifications as opposed to a company-based classification. And at least that is the way it has been looked at in Europe. But there's still no clarity around how the Parliamentary Standing Committee was envisaging it. And I think given all of this, there was a realization that the report was probably just the beginning of a conversation. And with that, there has been a Committee of Digital Competition Law, which has been set up. The committee's mandate is actually to figure out whether a digital competition law in India is needed, and if so, what would be the contours of that law. We hope and we expect that this committee, which brings together representatives from the company, from the government and stakeholders from the industry, is possibly going to come out with a second version of what we saw in the Big Tech report, which is going to account for issues that can arise if these recommendations of the current report are taken exactly as they are. So we hope for a lot more clarity, as well as some good assessment of whether we need it in the first place or not. If you could move on to the next slide, Avinash. Thank you. So where are we right now? Wrapping it all up, we have the amendment bill, which is likely to be introduced in the second leg of the budget session in the Parliament. A lot of interesting changes, as Avinash mentioned, on the anvil. But we have the CCI, which is currently not great. So for a lot of us competition practitioners, time since October has been unwanted holiday from regulatory intervention at the CCI because nothing has been happening. That has been a nightmare because mergers were not getting approved. Nothing was moving within the commission, which finally forced the CCI to invoke the doctrine of necessity to approve mergers with only 2 members that are remaining at the commission. We hope that changes soon. We hope that newer members are appointed for the commission to full-fledgedly start taking control of the activities. And currently, this doctrine has not been extended to behavioral issues, and we hope that it remains that way. Finally, we have the CDCL, which is being set up for drafting a Digital Competition Act and looking into it. And we hope that the CDCL will be able to take a more holistic view about the digital sector in India, the needs of the digital sector in India, and design a law which is not based on the DMA. I think with our experience in the privacy space, all of us are aware that Europe is not the gold standard for everything. There is a need to look at the local conditions and design something which is more locally appropriate. So we hope for that to happen. And in the meanwhile, we continue with the CCI with 2 members, hoping that a judicial member gets appointed soon. Avinash, you can move to the next slide. And I think to round it all up, we had one slide of how things are looking for companies. As you can see, it's not looking very good for the big tech space. On the enforcement side, on the combination side, procedural as well as administrative side, we're seeing a lot of tightening news of regulation around big tech. Newer laws, additional regulators, additional burdens on them, especially around the combination space where there is a likelihood that they may have to inform some regulator about each and every merger that they're doing, irrespective of any kind of thresholds. So looking a little bleak there, but for other companies we have, and even for big tech actually, there is a little glimmer of hope with the way settlement and commitment regimes are coming up and how the CCI has been reducing the timeline required for approving mergers. But yes, interesting space for us to watch ahead in 2023 to see where we finally head in terms of competition law and policy. That's all from us.
Great, thank you. I'm going to invite Avinash to come on screen and give us a U.S. perspective. But while we're waiting, we got a question from, thank you, Avinash, if you want to, thank you. We got a question from the group. When does the period of limitations begin? Is it when the individual knows about the incident or when it actually kind of occurred?
Diksha, you want to take this? Or
yeah, please do, and then we'll turn to Ashish.
Happy to. So currently the limitation period is going to be 3 years. And typically limitation starts from when the cause of action starts, which translated to very simple language means when the issue occurs. So knowledge may not be the appropriate trigger for determining limitation. It is going to be when the conduct started or triggered. What may be helpful, especially for cartel cases, is the conduct may start in 2015 and maybe continued right up to 2020 when you as an informant got to know about it. So in that case, 2020 is going to be taken into account and you can file an information up to 2023.
Great, thank you. So bringing this to the U.S.-India side, you know, Ashish, you're a former U.S. regulator. You have some experience here. What are your initial takes? And I want to mention something that Diksha mentioned about the gold standard and maybe European competition law not being the gold standard. And what is the gold standard these days? Over to you.
Well, thanks, Jay, and thanks, Avinash and Diksha, for that very helpful overview of what's happening in India. I thought I would offer some observations from the U.S. perspective and also provide a brief update as to what's happening here that might be of interest to some folks on the call. So, first of all, obviously what's happening in India is hugely important to our bilateral relations. The U.S. Chamber has been an enormous supporter of the Indo-Pacific Economic Framework announced by President Biden, but it's also hugely important as a possible indicator of what's going to happen around the globe. I think Diksha mentioned that competition policy is now on the front burner. So it's not just India, it's Turkey, Saudi Arabia, Korea, Canada are all looking at reforms along the lines of what India is looking at. So I think what happens there is going to influence what happens around the globe. So from the U.S. perspective, I'll say that there are some good things about the proposals. Some of the procedural reforms, the shortening of timeframes for investigations, for example, the decriminalizing of some conduct, I think are all things that certainly the U.S. Chamber could support. I think are good things on the merit. However, on balance, I think that Diksha asked just a great question, which is, what are these proposals designed to address? What is the problem you're trying to solve? And looking around the globe, it looks like there are really at least two answers to that when we talk to other competition agencies and governments. One is there does seem to be this sense that there's a need to do something about the technology sector in particular. It's big. It affects hundreds of millions of users. So we need to do something, even if there isn't a particular problem that they're trying to resolve. And I think the second issue, particularly in Europe, is just protectionism. And there's a sense that Europe's tech sector has fallen behind the United States, and by promulgating DMA style reforms, they hope to catch up. And I guess the message, one of the messages that we deliver is to think long and hard before going down that road. So by any measure, the U.S. tech sector is more dynamic and more innovative than Europe's. Market capitalization, sales, employment, innovation, and part of the reason for that is that the U.S. competition policy framework rewards innovation and it encourages companies to, for example, enter into new lines of business. We think that's a good thing. So it's disappointing, and I think should be concerning to the business community to learn that India is thinking about a DMA plus style reforms, because over the long run, and I think the evidence shows that approach to competition policy is likely to damage domestic industries, lead to less innovation, and of course, lead to less options for consumers. So we look forward to ongoing discussions, with our counterparts in India. A little bit on what's happening in the United States, for those of you who might not be following it closely. So as you may have seen, there were some very aggressive bills that were introduced into Congress in the prior Congress over the last 2 years that would have very much remade U.S. competition policy and brought it more in line with what's happening in Europe. So much more restrictions on the ability of large companies to acquire smaller companies, more requirements on them to share data with with their competitors. All of those congressional bills failed to make out of Congress. There's a thought that some of those ideas will be reintroduced in this current Congress, but no one seems to think they have much of a chance of moving forward. At the regulatory level, there is quite a bit of activity, though. So the U.S. Federal Trade Commission and the Department of Justice are both moving forward with very aggressive lawsuits and investigations against really all of the big U.S. tech companies. In addition, there's quite a bit of regulatory action. So the Federal Trade Commission has announced this new interpretation of an old law that would give them much more authority to declare illegal what to date have been very routine forms of business conduct, such as exclusive contracts and loyalty rebates. So this new policy statement from the Federal Trade Commission is going to be litigated sooner rather than later. So I think we'll have some clarity from the courts in the near future as to whether U.S. competition policy is going to stay more or less as it has been, or going to very much move closer to Europe's. Beyond that, some of you may have seen, if you follow the U.S. Federal Trade Commission, that the long-term head of our Office of International Affairs, I say our because I'm an alumnus of that agency, but the long-term head of the international division, Randy Treitel, has departed. The current acting head is a woman named Maria Coppola. There's an expectation that she will be named the permanent head of that office. So I think once that happens, you might see some more activity and engagement from the Federal Trade Commission, at least in terms of international affairs. Finally, I should mention that the U.S. Chamber has been pushing very hard for the IPEF to include some of the procedural protections regarding member states' competition investigations that we see from the International Competition Network that are sort of best practices. These are sort of procedural safeguards, notice, due process requirements, and so we're pushing very hard for the IPEF and its members to recognize those procedural protections. So fingers crossed there. Thanks, Jay. Back to you.
Sure. So is it fair to say that in the past there had been a lot of coordination between the FTC and CCI, that in the recent past that hasn't happened, but perhaps in the future there may be a restart of some of those sorts of interactions? And then as a follow-up, yeah.
Right. I would think there's certainly an interest on the part of U.S. regulators in increasing cooperation with the foreign counterparts, and that goes for India, Europe, and across the globe. And in fact, there's been some criticism of U.S. regulators for doing a little bit of too much of that, and in fact, asking regulators abroad to do some of the work that U.S. agencies should be doing.
Great, thank you. So regulators in the competition arena are more coordinated than many other sector regulators globally. A lot of those discussions occur at the American Bar Association spring meeting. It's probably the largest competition event of the year. It's coming up next month in Washington, D.C. What do you think some of the topics that are going to be, talked about? Maybe not the agenda, but some of the sidebar conversations that people may be raising.
Is that for me, Jay?
Yes, it is.
Well, all of the above. I think certainly any multinational company is paying, very close attention to what's happening in India and really around the globe in terms of international policy. But I think, as Avinash started off with, there is literally so much going on. It is hard to keep track of. So even within the United States, we have, of course, 50 states and in state legislatures. Several of them are considering their own antitrust bills that would move towards an abuse of dominant standard. Our neighbors to the north, Canada, is right now undertaking a very robust consultation that again would potentially move Canada towards more of a DMA style regulatory regime. So there are no shortage of topics to discuss.
Wonderful, thank you. And of course, USIBC and the Chamber of Commerce, we always look forward to an event with Chandhiok around the ABA with the Competition Commission of India and an Indian delegation. So a plug, look out for that information in the near future. I want to open it up to our question and answer portion, but I want to just share that we're really pleased to have as a special guest Mr. Dahendra Kumar, who was actually the first chairman of CCI and an old colleague and friend. You weren't formally on the agenda, sir, but I certainly see you here. You have so much wealth of experience, not only in competition writ large, but at CCI. As we open up the question and answer, I want to give you an opportunity to share your thoughts on this dynamically changing environment. What's going on in India? Where does this go? Is this a good thing, a bad thing? Just over to you for maybe, 2 to 3 minutes, just to help set us off for some question and answers and dialogues. Over to you, sir.
Thank you very much, Jay. It's an honor and privilege to be here today and also get this opportunity to speak and share some of my thoughts. I've been writing very frequently on some of these issues, and my articles have appeared in various newspapers, including Economic Times, Financial Express, Hindu Business Line, and so on. These two reports on the reforms in competition law, the 52nd report of the Standing Committee of the Parliament on Finance, and the 53rd committee, which is frequently referred to as the Big Tech report. So these two reports have raised a lot of concerns and a lot of interest. But what I feel that as far as this discussion today is concerned, it is slightly premature in my view, in so much as this committee, which has been constituted by the Ministry of Corporate Affairs under the Secretary Manoj Govil of Corporate Affairs, comprising 16 members in all, multidisciplinary and multi-sectoral. Probably we have to wait a little bit in order to see what the recommendations are. Possibly some of the inputs from this discussion today could be sent to them. Various other stakeholders are also sending them, including the startup community and many others. There are several other developments which are taking place. For example, in the case of Google, their appeal was dismissed by the Supreme Court, and the NCLAT, the Appellate Tribunal, is going to hearing what's going on, and the decision in that case would also be of some relevance on what would be the need of regulating big tech and what are the various issues which have been thrown up. So that is again something which is relevant in this context. The third thing is that while the matter is pending before the Parliament, and of course the Parliament's view would be supreme, what's going to happen, there are a number of other legislations which are in the offing, including the Digital Protection Act, the IT Amendment Act, and several other legislations which are going to be relevant in terms of either tightening or whatever you might say, or regulating the digital space. So one has to see at the end of the whole thing, because why the need arose. If you look into the recommendations of the Standing Committee, they felt that because of the network effect, the digital biggies, they tend to acquire dominance in the digital space very quickly. And as a result of that, the existing tools of competition law were inadequate. These tools were given in the Act in 2002. Enforcement began in 2009, and as you rightly said, I was privileged to have been the first chairman. And what has been felt that during the last 13 years, those tools are not adequate in ensuring that these big tech companies in digital space do not acquire dominance or abuse their dominance so quickly. So there was a talk of ex-ante regulation, and there was a talk of these systematically important units and things like this. So a lot of things are happening at the moment. A lot of churning is going on. But to come to a conclusion where it will be at the end of the day. And this is all coupled with the fact that the government is extremely proactive, encouraging the FDI into India, the big tech. Nothing is being done to give out an impression that India is in any way discouraging investment and technology in this space. In fact, the inflow of technology is a record high at the moment. The digital era, particularly in the G20 conference where India is chairing the moment, I personally feel that we can expect a lot of liberalization going forward. So I would not add anything further to it at the moment, except that in my view, what is going to happen could be a very good and positive step forward if we wait for some more time. Thank you so much for this opportunity. I'll be very happy in future in case you were to associate me for anything in deliberating this issue. Thank you.
Thank you, and do let us know if you're in Washington, D.C. for the ABA conference. So I think your wise counsel was that there's a process in hand here, there's an opportunity to engage, and that we should take our concerns and comments and engage with the government of India, and that they would welcome those as part of an ongoing discussion. So thank you for those. We have some questions from our members, and I want to turn back to Avinash and Diksha to sort of help us through that. The Competition Amendment Bill 2023 kind of help us out, for the actual process. We're going back to a second half of a budget session. Is it going to be passed? Might it be passed? Are we looking at a monsoon session, which is typically in the July timeframe? Tell us where we're going on the competition bill, please.
Are you asking me or anybody else?
I was asking Avinash and Diksha, but opening it up. Avinash, what are your thoughts?
Yeah. A little unpredictable, but I think as of now, the expectation is that it might be presented in the second leg of the budget session that's in March. But things have gotten delayed in the past. So, I would say take it with a pinch of salt, but our expectation is that possibly in the budget session.
Good. Deepsha, speed round. Budget session, monsoon session, or 2024?
It's either going to be the budget or monsoon. If it crosses that, then I think 2024 is the grand election year. So I don't expect the competition bill to take precedence. So if it doesn't get passed in this year, then I think there's going to be yet another wait.
Great. Mr. Kumar, speed round. Budget session, monsoon session, or 2025?
I personally feel it's going to come up in monsoon session. That's my personal assessment, because this committee which has been set up, I think they have also to submit their report, and as a result of which there could be some changes. The budget session has too much in hand, but my assessment would be that it might go up to the monsoon session.
Okay, wonderful. So another question, when I was involved with CCI back when I was in the embassy and the FCC did a lot of workshops, issues of dawn raids came up. Where do we stand on dawn raids? Are they involved in the amendments? Just kind of help us understand that important aspect of enforcement.
Yeah, so earlier, you would remember that there was an enabling provision for dawn raids in the competition law, but the procedure was, there was almost a referring provision. So the procedure was all prescribed under the Companies Act, and there was only a cross-reference in the Competition Act. Whereas now in the latest bill, the procedures are sought to be defined within the Competition Act. Largely, the procedures remain unchanged, but there are certain limitations that have been introduced in terms of how long the DG can retain documents for. So there's a time limit of 180 days that he can retain seized documents. And after that, there has to be an order to extend that a little further. And again, I would say in terms of just talking in terms of hits and misses, Again, I think the one major miss is that there's no clarity on privileged documents. That is, of course, a major bone of contention in dawn raids, but unfortunately, no clarity in the procedure so far.
Wonderful. Well, we're coming up to time. I want to give our members one final opportunity to raise your hand or ask a question. Please do that now if you would like. Going once, going twice. Okay. Well, this was, oh, I see a question. Kriti, over to you, please.
Thanks so much, Jay. Hi, Avinash. Hey, Diksha. Good to see you again. I had a very quick question just to understand your assessment of what is substantively different between the Parliamentary Standing Committee that came out with the report and the new committee that's been constituted. Is the only distinction that the new committee has been empowered to potentially create a law, or are we expecting any substantive distinction between the old committee and the new committee's final findings in that sense? Thank you.
Thanks, Kriti. I think an extremely interesting question, and I would want to go back to the terms of reference of the Parliamentary Standing Committee of Finance. When they were examining this issue, they were doing it under the topic of anti-competitive practices by big tech companies. A very interesting choice of words, and contrasts really well with the terms of reference for the new committee. So as I said, my sense is that we're looking at a possibly more holistic, comprehensive report compared to what we saw from the Parliamentary Standing Committee. It's almost like going back to the non-personal data time when you had report after report, where each of the report was an increment based on understanding received from stakeholders. So I imagine something similar. One of the terms of reference is to actually see whether the Competition Act is sufficient and if a new law is needed. So hopefully greater discussion on that. And if they do decide the new law, then of course, they have the terms of reference allow them to frame the law as well. So I see discussions on all those parts and something which is more comprehensive than what we saw from the Parliamentary Standing Committee.
Thank you, Deepja. And if we're following the data protection pace, we'll see a 5th version in 2025. Job security, I suppose, for all of us. Ujjwal, a question for you if you want to come off of mute and ask it to our speakers, please.
Yeah, just one, the provision of pre-deposit of 25% of penalty. Can it stand the constitutionality in India, seeing that there is a right to appeal? It will also curtail that, and similar provision in Brazil has already been held unconstitutional. So, what's your take?
I believe, obviously, I think it could be subject to a constitutionality test, but in India, such provisions are not uncommon. We have similar provisions in the Consumer Protection Act, for example, which require pre-deposit of penalties for appeal. So my guess is that it would withstand it, because in India, it's very common. There are a lot of other provisions which have such pre-deposit requirements.
Thank you. Thank you.
Great. And as a moderator prerogative, I'll have the final question. The issue or the connectivity between the Digital Competition Act and the Digital India Act, essentially the update to the IT Act. What's the connections? Minister Chandrasekhar said that the Digital India Act, we would see a draft at sometime in January. We're obviously closing in on March. We haven't seen a version. There is some discourse that the Digital Competition Act may have scrambled the government's thinking about data governance overall. Can you provide us any insight? And I'm going to go to Dharendra, and I'm going to go to Diksha, and then Avinash, you will get both the first and the last word. So over to you, Mr. Kumar.
Thank you very much, Jay. That's a very interesting question. Indeed, there is a multiplicity or plethora of various laws in the digital space. And as you rightly said, the Digital India Act, the Personal Data Privacy Act, and this thing which is coming up. So one doesn't really know where it would link with each other. And that's why I was saying that probably it's a bit premature. The draft of the Digital India Act and the other acts are yet to come into the public space, but there would be definitely a few things which would be overlapping. But the objectives are the same. The objectives are basically to ensure that the interest of the consumers and interest of the startup community is taken care of, particularly the digital ones. And there are lots and lots of them at the moment in India. And also the digital startups, for example, they have also submitted, as I understand from today's media reports, a representation to this new committee, which had been constituted on the 6th of February, that in addition to the 16 members who are part of this, they should also get an opportunity. So what I mean to say that the contours of where it starts and where it ends and the linkage among them, it is not very clear till now. Thank you.
Thank you. So a focus on consumer protection and startups and the objectives of all of these perhaps overlapping bills. Thank you. Deeksha, over to you, your thoughts on the linkages.
I'll keep it very quick because I think Source very accurately put it out there. There are bound to be overlaps. We are looking at something called CIDs under the Digital Competition Act. Intermediaries by design are regulated by the IT Act and are bound to be regulated by the Digital India Act as well. One area where we know there is definitely an overlap is advertising policies, because MeitY has come out saying they will regulate it. And in the other areas, it remains to be seen how much of overlap is there, but there's bound to be some overlap. So a lot of flux there. We've seen this government to adopt a more coordinated approach towards policy making. And one hopes and expects that this committee, as well as the MeitY, because there will be a representative of MeitY on the committee, they're able to comprehensively come up with something that doesn't create multiplicity of rules and regulators, because that has not been good news for the industry and that has not been good news for the regulators.
Thank you. Avinash, over to you, sir.
Yeah, no, I think, again, keeping it very short, I think I agree with both Mr. Kumar, sir, and Deeksha. And I think I think just to add to what Deeksha was saying, I think the Digital Competition Act, as Deeksha pointed out, this is still a committee and it's a committee in the works. So we hope that perhaps if they decide that a law is required, they would then take into account the existing drafts of the Digital India Act and the Data Protection Bill, and hopefully minimize any conflicting overlaps. So that one hopes that would happen.
Thank you. And with that, I want to thank our experts here, Ashish, Avinash, Deeksha, and our surprise guest, Mr. Dahendra Kumar. This was really, I think, an informative session. It is recorded. It will be available for our members. We also will share the slides. On behalf of USIBC and the Chamber of Commerce, we really value your time. We believe that competition policy is fundamental and foundational to not only the larger economy, but to the US-India relationship. It's an area that we're going to consistently look at over the course of this year. We've heard today that it's going to be a dynamic time when we will be involved and hopefully impactful in that process. And next steps, look out for our next activity around the ABA next month in March. In the meantime, let me wish everybody a very good morning in Chicago and Washington, D.C. and elsewhere in the United States, and a good evening for those of you in India and beyond. Thank you very much and have a good night.
Thank you, Jay. My compliments to you for a very dexterous, beautiful, intelligent, brilliant moderation of the whole thing. Great.
Thank you. You're making me blush, sir. Thank you, everybody. Have a good evening.
Thank you. Thank you, everyone.
Thank you, everyone. Bye-bye.